Thank you very much, Senator King.
A large standing army in time of peace has ever been considered dangerous to the liberties of a country. George Washington. The founders of this country understood the dangers of a military presence within our borders. James Madison, a standing military force with an overgrown executive. That sounds familiar, doesn't it? An overgrown executive will not long be safe companions to liberty. Again, Madison at the Constitutional Convention, the means of defense against foreign danger have always been the instruments of tyranny at home.
Do you have a mock-up?
Patrick Henry, a standing army we shall have also to execute the execrable commands of tyranny. Finally, Samuel Adams, a standing army, if it shall be established, will undoubtedly be permanent, and the people will become slaves. I want to sort of broaden this discussion from the specific to the more general. What concerns me about the cases we're talking about today is the normalization of deploying the military domestically. We've got laws about it, and you guys can thread the needle and talk about how this or that deployment is okay or not okay. But the idea of deploying federal troops into American cities, particularly against the wishes of the governor. Mr. Devilson, you said something that was borderline humorous. You said, we'll work closely with state and local governments. That didn't happen in Illinois or in California. So we're talking about a broader issue here that I think is extremely dangerous. And the reason it's particularly dangerous in the present moment is we have a president who has a very low bar as to what constitutes an emergency. I live in Maine, on the border of Canada. There is no emergency with Canada. And yet this president declared an emergency in order to impose tariffs on Canada, which is wrecking their economy. So the idea that we are saying that the president has the power to, in his own mind, decide what an emergency is and then deploy troops into our cities, I think is exceedingly dangerous. And the people who founded this country thought so too. So I think we can talk about the legality of a particular deployment here or there, but the principle is what's so dangerous, and the founders of this country understood that, and in many, many ways. For example, in the Constitution, the Army, we're only allowed to fund the Army for 2 years. That was for a purpose, in order to limit the whole idea of a standing army. We now have a standing army. We have an all-volunteer army. And then we have this quick reaction force, which has essentially become a special army on behalf of the president. And I'm not necessarily, I mean, I do criticize this president for his low standard of what constitutes an emergency, but this is a dangerous precedent for any president. And that's what concerns me about this, gentlemen. And Mr. Young, you're familiar with the concepts and the principles of the Constitution. Speak to the more general question that I'm raising, not the specifics of Washington or Los Angeles, but the idea of the normalization of use of troops in our streets, I think is extremely dangerous, and the founders of our country would I think, agree.
Thank you, Senator. I would just say that immediately after the passage of the Constitution, Congress passed a law that would delegate their authority to determine when the militia could be called forth, and they delegated that authority to the president. George Washington himself, whom you quoted, immediately put that to use. And George Washington mustered 13,000 militiamen and marched them to Pennsylvania to suppress what was...
Shays Rebellion.
Sir, it was the Whiskey Rebellion.
Whiskey Rebellion.
Right? The Shays Rebellion was in Massachusetts. Whiskey Rebellion is in Pennsylvania, where they tarred and feather tax collectors. And the president sent them there to protect federal functions and the officers who were performing their duty. Very similar to what was there. And that original statute, sir, it had a provision in it that a federal judge would need to make the determination that the laws were not being able to be enforced. And after George Washington moved the troops to Pennsylvania, Congress came back and amended that and took that out and put it within the discretion of the president. And it wasn't long after that that the Supreme Court The Supreme Court reviewed that muster. The Supreme Court went in and reviewed an actual mobilization of the militia to deal with an exigent
So is
circumstances.
there no realistic check on a president? Can the president declare an emergency? And I think it's been testified here today, what's bothering everybody is this president keeps using the term the enemy within. And he's not talking about al-Qaeda, and he's not talking about the Russians, and he's not talking about the Chinese. We can't tell quite who he's talking about, but the use of the term the enemy within as a justification for deploying troops, maybe it's a question of judgment and what the standard is. And it just strikes me, I mean, you seem unconcerned about this, but
Well, Senator, if I may, I think the Supreme Court has directly asked that question in the context of the president's ability to mobilize the militia. And if I may, I would answer by giving you some of the language of the Supreme Court. And it says, by whom is the emergency to be judged? Is the president the sole and exclusive judge as to whether an emergency has arisen? Or is it to be considered an open question which every officer may decide for himself or contested by every militiaman who should refuse his order? The Supreme Court unanimously ruled that the authority to decide whether the emergency exists belongs exclusively to the president, and that his decision is conclusive on all other persons. And the Supreme Court again, in another Supreme Court decision, said, after the president has acted and called out the militia, is a circuit court of the United States authorized to inquire whether his decision was right? If the judicial power of the United States extends so far, then the guarantees in the Constitution are a guarantee of anarchy and not of order. And then lastly, with respect to whether or not there's a remedy, the Supreme Court recognized that there might be circumstances where this may be perceived to be abused. And it says, the law does not provide any appeal from the judgment of the president, and for any right in a subordinate officer to review or question his decision before they enforce it. It says such power may be abused, for there is no power for which is not susceptible of abuse, but the remedy for this, as well as for any other official misconduct, if it should occur, is to be found in the Constitution itself. And, sir, that's the Supreme Court's decision.
and what
on
is
this
that
issue.
remedy that's in the Constitution? Impeachment? Elections? What?
Elections. And I think one of the frequency of elections is one of the things in the Supreme Court decision of Mott, Martin v. Mott of 1847, is the one of the factors that the Supreme Court discussed as to a remedy when the people in this body may disagree with the president's determination that an exigency exists, sir.
Thank you, Mr.
What
Young.
Mr.
citation
Young,
was that,
could you, counsel behind us would like for you to state for the record what case you were quoting in answer to Senator King?
Yes, the language comes from Martin v. Mott, which is 12 Wheat, 1827, as well as In re Debs, and Luther v. Borden, which is at 48 U.S.C. 1847.
By the way, Counselor, the organization that you work for is the Department of Defense, 10 U.S.C. 111A. Thank you.
Thank you, Senator.
Thank you for repeatedly making that point, Senator.